State against Rittenhouse. Appearances as before with the jury in the jury room. And yesterday I misspoke. Age takes its toll. I thought yesterday was Thursday at the end of the day. Maybe it was just because it seemed like a longer day, but in any event, so anything I said about schedule is somewhat compromised. It would be ideal if we could finish on Friday, but let's see what happens. Anything else before we get started?
Two things, Your Honor. One, my next witness is going to be Dr. John Black, and his testimony will involve a computer program and demonstrative evidence with all videos that have already been entered into evidence, and how he establishes the times that he'll testify to. And what I'm asking the court to allow is to have him testify at this witness stand to my left, so that he can be hooked into the cord and manipulate his computer.
Any objection to that?
Yeah.
Okay.
And then there's the Armstrong Report. There's been new photographs, and there's already been testimony about some old I shouldn't say photographs, enhancements of video evidence would be the correct statement. It's my understanding that Mr. Armstrong testified that the video program he uses is Amped, and Amped has an internal printout of everything that the operator does on it. So if I do X, X is documented, you push the button, it says he did X. My understanding is that there should be a report for that, and then the new photographs today. And our question comes into, on testimony, on cross-examination, when he was testifying to what he did to the video, there's a definite discrepancy between the aspect ratios and the amount of pixels, so I'm asking for that report. And then the new photographs, which the state intends to introduce in the rebuttal case, I would like the report from Amped for that, so that we can check that. I spoke to Mr. Binger, he said he would try to do that. I don't know if he can or he can't.
Are you saying the program is named Amped?
Yeah.
He needs a microphone though.
Yeah.
My understanding from Senior Examiner Armstrong's testimony is that he used a program known as Amped, A-M-P-E-D, the number 5. If he did use that program, Amped 5, which is a gold standard of forensic analysis, Amped 5 does produce a report of all manipulations or actions taken upon the start to the finish. That's the report I think we're talking about right now.
Okay.
I just think that those reports, there should be 2 of them.
I didn't hear the last thing you said.
There should be at least 2 of them, one for each
Okay.
change.
Anything else?
Well, I mean, we don't have to, I don't believe we have an obligation to provide that. This is a very late request. This will probably push rebuttal into tomorrow, because he's gonna have to go, if these reports exist, that I am not saying that they do, he'd have to go back he's on his way here now. He'd have to go back to the crime lab and get them.
Well,
So-
can you reach him? And
I mean, I can certainly try.
why don't you do that? I'm not going to worry about anything till it happens. Well, let's see what can be done on that. And then, were you done on that?
Yes.
Then I did get Mr. Binger's transmission of last night, which unfortunately was not. Was there other than the initial minute or two, was there actual video, or was it black screen?
There was, it's like a 20-some minute compilation video with the defendant's voice.
Well, let me try it. Let me try opening it here, because at home it was there. I was able to hear the audio, but the video was all black. So I don't know what the significance of that is until I look at it. Hopefully it'll open here. I guess that's it. All right. Anything else?
No, Your Honor.
I'm going to, I guess, forward an email that we just received a phone call from someone who supposedly spoke to a juror, or spoke to someone who spoke to a juror. I don't think it's anything, but just for the, just to
That's
be,
pretty, I didn't mean to interrupt you.
I'm sorry, just to be transparent, when we get these communications, we are giving them to the court.
Excellent, and appreciate it. And we've gotten inundated, as would expect with a case with this degree of publicity, and all kinds of wild things are said, and as long as you folks are aware of them and can deal with it, or ask me to deal with it to the extent that I'm able, we'll do it. I would hate to be someone who got caught doing some of this stuff. All right. Anything else?
I'm just going to call Mr. Armstrong. I just want to verify.
Yeah, go ahead.
So you want for the...
TV people, how long will it take to move your cameras? Okay. I guess that's the plan, so.
Jury.
Are you ready to roll them? All right. Ready for the jury?
Yes.
Oh, one more thing. I have now opened again the link that you sent me from the Washington Post, and it won't open now. I was doing better before. Oh, wait. Yeah, okay. Okay.
During a summer marked by protest.
Yeah, this looks like it's complete, so I'll take a look at it at the break. Okay. Get the jury down. Good morning, and good morning, everyone. And you're seated a little differently for convenience purposes. Some technical reasons have dictated this temporary change, and it makes no other difference in the case. And then I wanted to just observe that it's Veterans Day. And any veterans on the road, on the jury, or anywhere else? Well, that's unusual not to have at least somebody in here. But Dr. Black is, what branch? Army, sir. Okay, and I think we give a round of applause to the people who've served our country. Okay, so you may proceed.
Defense will call Dr. John Black to the witness stand.
Raise your right hand. Do solemnly swear the testimony about the given matter with the truth, the whole truth, and nothing but truth, so help you God.
I do.
You may be seated.
Doctor, I'm going to hand you a series of documents and then ask you to testify and authenticate to them, please. First document I'd like you to look at is Defense Exhibit 140.
Yes, sir.
And what is that?
This is the curriculum vitae of me, Annex A, that was tendered with my expert report.
And how long is that document?
43 pages, sir.
And does that include your life and professional experiences?
It includes the highlights of them, but yes, sir.
And what I want to get into is a little bit of your background as it applies to this case. Have you ever worked in a law enforcement capacity?
Yes, sir, I have.
How long?
Approximately 23 years.
Where?
Washington County, Oregon.
Is there a city around there that we?
It's the first county to the sort of, if you're looking at it, between the coast and Portland.
Okay. And what were your duties in that department?
My duties range from a lot of stuff. I started as a patrol officer. It would be actually a deputy. From there, I was a corporal. I became a sergeant, again in patrol or operations, what you commonly think about as patrolling. I was also a training sergeant. I then became a lieutenant, and there's 4 divisions in there: corrections, patrol, investigations, and support, sort of you think the way it operates. And then I was a lieutenant and in some cases acting commander, which is the person that oversees all the operations within those individual divisions. Additionally, I oversaw professional standards, which is the unit that oversees if things are done right, if things can become better, to include internal affairs. And then I was also the person that oversaw and designed the use of force program within that agency.
At any time in the employment in law enforcement, did you have an opportunity to work with videographic evidence?
Oh, absolutely. As a deputy coming up, we would commonly use video type of evidence in our investigations. I mean, think about robberies or anything else, and you have ATM video or similar type of things. When I oversaw such things in the jails are commonly monitored with cameras, and if there was allegations of complaints, and for a period of time as the jail operations lieutenant, I oversaw every allegation of a complaint. We would review evidence to include the video evidence. That would have been the time frame for that. As I oversaw the detective division, detectives which oversaw sex crimes, homicides, car task force, fraud, you name it, it was underneath the detective division. Again, video evidence is pervasive. It's used throughout, and then we would have to make sure that the examination of such video evidence would withstand challenge in court, and more importantly, that we were doing it correctly. So I would commonly be, as the head of the unit on the big cases, make sure that sort of a quality control, I guess would be the best way to put it.
And in your military experience, did you have any occasion to work with videographic evidence?
Yes, sir. In the military, what the branch I was in, the service, the Army, my entire time was in what's called Special Operations. And because of that, I have several what they call military occupational specialties, or MOSs. One of the MOSs I have, I think the last count was about 7 of them. One of them is specifically about intelligence, just like you think about intelligence to gather information. As part of being an intelligence qualified officer or non-commissioned officer, is we would routinely look at surveillance video. We would use surveillance video to plan operations. We would covertly make sure video is happening, drone video. We use video in our how we operated. Body-worn cameras were with the military long before they were with police. And we would have to make sense of this video, or when it came in from another thing, you have intelligence units, there was an entire portion of that unit designed to focus on what's called IMINT, or imagery intelligence, IMINT, Court Report. And then so because of that, we routinely both used it, operated with it, similar type of things.
And in the intelligence capacity, did you analyze, enhance, and do things to video?
When required.
Okay. When it was
When required.
And in the course of your profession, let me back up a second, I apologize. What was the highest rank you achieved in the military?
I retired from the military after 30 years with the rank of Sergeant Major, which, to put it lateral to other services, is an E9, or enlisted rank 9, which is, you have a Command Sergeant Major, which I did as a, we'll call it a temporary duties, but I remained primarily an Operations Sergeant Major, which is the highest non-commissioned rank in the military.
Now, in this case, I engaged you for several tasks, but one of those was video analysis, correct?
Video analysis is in support of understanding the event, yes.
Okay. And are you certified in the operation of any video programs that you used in this case?
Yes. I used a video program known as Input ACE, version 2.6.3. Input ACE is a program specifically designed to allow people without a lot of high-level skill, like high computer forensics or anything else, to examine video in such a way that when you examine it, you're not doing things to it, like altering it or anything else. That when you're looking at it, you can have some trust in what you do with it, that you're looking at the best that it can be with what it can provide. And within Input ACE, I'm certified at what they call both the operator level, and I'm also certified at the examiner level.
And what's the difference between an operator level and an examiner level?
So an operator level would, let's say, import videos, allow them to basically transfer with codecs or anything else. You could play them, maybe cut a couple pieces out, do these type of things. At an examiner level, you're actually doing, we'll call it manipulation. In other words, you're scaling it, you're looking at things, and so you have to have an understanding about how that happens. So, for example, there's certain ways, and I think you heard earlier in the testimony of Senior Examiner Armstrong, he used the word interpolation. So with interpolation, there's certain ways things get interpolated. Not really a word, but it will work for now. And so the thing is, if I don't understand those things, I can't have trust within what I'm working with to better understand the totality of the event and what I'm looking at.
Now, when you look at videographic evidence, is frames per second something that's important?
It's one of the things, yes, sir.
Tell the jury what frames per second means.
Yeah, I mean, it's frames per second. So when you look down on your phone and it's recording a video or something else like that, you might see something that it's 30 FPS, the shorthand for frames per second. What that's telling you is, imagine if you were to take 30 still shots and just keep taking them at approximately 0.033 seconds, 30 frames per second, just take 1 second divided by 30. It would take 30 of those pictures in a continuous stream to make the 1 second that you're looking at, 30 frames per second. 60 frames per second. 60 frames just means that rather than having 30 still shots, you got 60 still shots. It's still 1 second, still the same resolution, potentially, depending if you haven't changed anything else. You're just getting more just micro snapshots with each point in time.
Do all videos run at the same frame per second amount?
Oh, no, absolutely not. And for example, in the examiner certifications, one of the things you're looking for just to get a feel is you look at things like frames per second and resolution and the codecs that it's using and these type of things. For example, 30 frames per second is common, but also 24 frames per second is common for high definition video because it's a more universal type of things. Or I want to say 23.95 something or 6 something is used for what they call NTSC. N, November, Tango, Sierra, Charlie, which is more of a European format like PAL. So the fact is, the short answer is the frame rates will vary depending on who's using what kind of camera or equipment or what they're trying to do.
Now, resolution is also a part of the analysis?
Resolution is part of understanding the video, yes.
And what is, how do you define resolution?
Yeah, it's defined a couple of different ways, but it really is talking about the same thing, and I think you heard it. Is it all right to refer to my notes?
Yeah.
May I refer to my notes?
Sure.
So, for example, in earlier testimony by Senior Examiner Armstrong, the idea of what they were looking at when they were talking about one of the exhibits is 1920 by 844. So the question is, what does that mean? It means 1920 pixels across and 844 pixels high. So if you were to take each one of those things, and basically a pixel is the smallest element within that picture of a single color. It's just like a Lego block, that's all it is. So 1920 across, 844 high. Well, if I spread that out, and I think you guys, I apologize, but I'm just to the jury, imagine taking your phone and as you spread it out, you get those sort of sharp edges where it looks like you're going to get a bunch of squares together. You're looking at the edges of where the pixels are. When those things begin to get smoothed out, a lot of times what that is, and the software does amazing stuff, is that software smoothing it out or what's called interpolating it, enhancing it, clarifying it. There's other verbs given to it. But so resolution is actually very critical.
Now, when one tries to look at different videos, but syncing them up, what role does sound play?
Yeah, so one of the things that's kind of unique with when you have it like an MP4 file, a very common type of file, in a video format, there's a soundtrack to it. Well, when I try to store video, most people, most programs, we want to sort of compress it up because it takes a lot of space. So what a lot of programs do is they'll take a look at it and say, hey, you know what, those 30 frames per second, 3 or 4 of them are just really exactly the same. So what I'm going to do is I'm going to get rid of those frames. So it's going to save me some space when I store it, right? But the audio track, which is completely separate, is not compressed. It's true against time. So what I do, and to understand and do the analysis, is I try to get as many different things, an audio track, take a look at the reports on what people perceive, take a look at the different videos, because remember, videos come from different perspectives. Sometimes we have them dead on, another person was to the left, and then what you do is you sort of put this all together to index it so you can get the best possible approximation of things like time and these type of things.
And is sound used to help sync up the videos?
Yes, sir.
And when you use sound, do you use a computer program to analyze that?
I do.
What is that?
It's actually Wavemaster Pro by NCH.
Okay. And when sound is analyzed, it puts together what would commonly be like a picture graph that's, excuse me, referred to as a waveform.
Yes.
And a waveform then allows you to see where the sound is for an event that's in the video, correct?
Well, it allows me to, so a waveform, if you've ever seen them, is those things that sort of have the big spikes in them and this type of stuff. A gunshot, for example. a gunshot has a loud percussive noise. I listen to the thing as it's playing. I see a big spike within the waveform. I can now mark that spike and say, that's the beginning of the gunshot. I listen some more, I watch the waveform shift, there's another spike. So what it allows me to do is it allows me to see a visual representation of sound, and now I don't have to be sort of hitting the space bar or using a stopwatch to hope I'm at or around the sound. I can actually mark that sound within it. It's the same if I look at it for 2 minutes or 20 minutes, the sound still occurs in the same place.
And you're using the frames per second, which is a known, to determine the distance between shot one and shot two, so to speak.
Actually, what I'm doing is within the sound software, I know that the time between, let's just say, and let's use gunshots, shot one and shot two, whatever that might be, but 2 shots. We'll call them shot one and shot two. As they play in front of me, I can mark them. I see a finite time measurement. I can now, with an index point back in the video, I can go back to the video and say, oh look, there's the same place that that sound is occurring in the video frames. Well, now since I have a known time from the sound, I can then begin to take that known time and back it up to the other shot. Now, a quick point of clarification. Sound does not travel absolutely perfect. Shorthand is basically, for the time in this place, the distance of 1,100 feet, which is about where this event was occurring. It would take sound about a second to travel. So if you were standing in the middle of all this, it might be half a second this way or half a second that way. So you make allowances for that, but you have to understand that sound isn't an absolute determiner. That's why you have to take all this in total when you're thinking about it. But that's part of the way that you index.
Now, in the course of your engagement in this case, you prepared a report which was labeled a supplemental report, Exhibit 141, correct?
That is correct.
And then, because there was new videographic evidence found recently, you added to a supplemental, and that is Exhibit 141, correct?
Well, 141 is the supplemental, as at least what I have in my hand.
The preliminary is 139 and the sup is 141.
That is correct.
Okay. If I misspoke, I apologize.
Yeah.
And you also did a timesheet, which is Exhibit 142, correct?
Also correct.
Now, what I was looking from you was for the total time of events that happened on August 25th of 2020, beginning with what happened at Car Source 1, correct?
Part of the timings, that's my understanding, yes.
And I gave you what would be a known time where Kyle is on video stating friendly, friendly, friendly. And you synced that amongst other videos, correct?
You gave me a known location to look at. The time is estimated, and then what I did is using that as a start point, I actually found other places to sync, and I worked backwards to that time.
And when you synced up all the not all the different videos, but the videos that you used in this case, you were able to get them to sync to what level?
In the first point, the sync points that I primarily use as points of reference. So just think about something that can be seen in a bunch of different things. So the sync points that I used was the high arc of the bag being thrown. You can see the different shadows and everything else. So from a video point, I was able to find that in a lot of different places, and I use that as a sync point. The other things from an audio standpoint is the gunshots. Now the gunshots can move depending on how far the person is away that's recording that sound. And in these cases, it could be 150 feet is about 1/10 of a second or a little bit more. So between the different things, I would say I have confidence in the different timings here plus or minus a tenth of a second.
Now, and then I asked you to break down basically into several groups, but event number 1 starting with friendly, correct?
Yes, sir.
What I would refer to as the transition from event 1 to event 2, correct?
Yes, sir.
And then event number 2 from beginning to end.
With the beginning being from the first strike with what's been shown as a person with a rock-like object.
Okay. And then the end of event 2 would be defined as what?
The fourth shot by Kyle Rittenhouse.
And from the end of event 2 going on to end being what?
Are you asking the point in time
Yeah.
or the actual measurement?
The actual act that ended your calculation.
So from the fourth shot by Kyle Rittenhouse in event 2 until the point where he's seen in the video raising his hands, and I refer to that simply as surrender to the police.
And you used, in your calculations of time and video, you used 6 different videos?
I looked at all of them. I narrowed it down to the ones that are most relevant so I could keep the timings consistent.
So what you're saying is there's 100, and I'm throwing out a number, but over 100 different videos. Those are the 7 that you used to calculate these times and values.
Those are the primary ones, and then I validated them with the other ones.
Okay. Now, let's get started with that. The start of event number 1, do you have that available?
Yes, as in, do you want me to show it by video?
Yes.
Okay. So at this point, and understanding what this point is, this is from, if you can see on your screen, the parent file. This would be the point where friendly is heard within the soundtrack, and obviously we can play that as well. So.
Please.
Your Honor, I'm going to object. This is beyond the scope of the court's order.
This is all timing.
One of those 5-minute breaks in the library. Let's do that. Please don't talk about the case. What's up, Mr. Binger?
Your Honor, the court has signed an order that specifies the scope of Dr. Black's testimony. That order indicates that he is going to be allowed to testify to what is contained on paragraph 19 of his preliminary report dated July 31st, 2021, in subsection 3A1. That subsection reads,
Page of the report, counsel.
page 19, subsection 3A1. This pertains to the shots at Joseph Rosenbaum. That subsection reads, the 4 shots occur in approximately 1 second with the times in hundredths of a second of 0.26, 0.25, and 0.23 respectively between shots 1, 2, 3, and 4. The court has also ruled that the witness can testify as to the information contained on page 22 of his report in paragraph 4A and 4A1. That pertains to the timing of the shots in what counsel describes as the second event, where the defendant shoots at the unidentified individual, Mr. Huber and Mr. Grosskreutz. And there's some timing information there. I won't read it right now because it's a little bit longer. But the court's order is very specific, that those are the items he can testify about with regard to timing. There's another section of his report he can testify about that has to do with sense-making, but right now, he's being asked about timing. And we have a document, which I guess is exhibit number 142, that was just presented to us this morning. It appears to have 31 different time entries on it. All of them, except for like 4 or 5 of them, are beyond the scope of the court's order. This document contains characterizations of behavior that this witness is not allowed to testify about.
I haven't seen the document.
Okay, so for example, he indicates with observation number 7.
Is there a copy? Go ahead, Mr. Rubin.
Observation number 7 is characterized by this witness as JR elevation change hyphen lunge decision point. What I'm interpreting that is Joseph Rosenbaum's elevation change lunge decision point. This witness is not, by the court's order, allowed to testify as to what Mr. Rosenbaum was doing or his intent or anything like that. This was the subject of our motion hearing, and the court has excluded that. There's other characterizations too. For example, the reference observation point number 15 and 16, referring to people striking the defendant. Number 19, striking the defendant. Number 22, striking the defendant. Number 25, the gun of Gage Grosskreutz pointed towards the defendant. These are all things that the preliminary report that this witness offered talked about, but now we have ruled, or we've agreed, and the court has ordered that he's not going to be talking about those things. So the scope of this document, 142, is well beyond the court's order. What he's being asked right now, and when I objected, is beyond the court's order. What he is characterizing in this Exhibit 142 in terms of his interpretation of what various people in the case were doing or what their intent was or anything like that is beyond the scope of the court's order. So my understanding from the court's order was he'd be able to say gunshot 1, 2, 3, and 4 to Rosenbaum happened in this amount of time. And then the second set of gunshots happened in this amount of time. And that's it, as far as the timing. The court's order was very specific as to that. So when we're talking about friendly, or throwing the bag or things like that, that's outside of that time frame.
I'm using demonstrative evidence to show how he reached these times. And it's all evidence that's already been testified to and admitted. Some of the evidence has been enhanced, just like the state enhanced the bag, some of the other photos. He's a licensed, trained video specialist. He has the background, and we're showing the jury what he used to get these values. And that shows how he did it and the reliability of doing it. And I'm not worried about what Mr. Binger's talking about, the comments or anything like that. That's a way that he found the times. And Your Honor, just time in relationship to video in this case is so important. Yesterday afternoon, Mr. Binger spent much time cross-examining my client regarding those approximately 30 frames from the BG on the scene. And that was approximately 1/10 of a second. And he spread it out, and what we're trying to do is show through video the true events of that night. And I believe it is with the court's order, because basically what we're looking at is an event, and the state can quibble with my time of when I started the event. They might say it's back 5-10 seconds before or whatever, but the total time of the event from friendly until he surrenders at the police car, 2 minutes and 55 seconds. The jury should know that. The events of each of the sub-events, the total time, the jury, they've been shown videos already of that.
Well,
If I may respond briefly.
yes, sir.
First of all, what counsel has just mentioned in terms of the overall timing is something he's free to play video and argue. The question is what this expert witness can testify to. The court has ordered specifically what he can and cannot testify to. Your order is one of limitation. It specifies the limits of what he can testify to. It's a fundamental notice issue, Your Honor. In his preliminary report, he didn't have information regarding the timing from friendly. That was a report from 3 months ago. We were not put on notice that there would be this testimony through this witness as to the timing of from the very beginning of all this to the very end. This Exhibit 142 is the first document we've received, and it was received today.
It was provided yesterday.
Don't interrupt. Don't interrupt.
It is the first document we've received from the defense pertaining to this witness with regard to the timing of the entire evening. It is beyond the court's order. We have not received proper notice as to this subject. I have no problem having this witness testify to observations 8, 9, 10, and 11. That is the exact scope of the court's order. Shot 1, shot 2, shot 3, shot 4. I have no problem with him testifying as to items, observations 20, 21, 23, and 26. Those are the 4 shots in the second incident with Grosskreutz, Huber, and the unknown assailant. That's exactly what this court limited him to. Those 8 observations on this sheet of paper. Everything else on this exhibit, which we just received, is beyond the scope of the court's order. We've not been provided notice of it. It wasn't in his original preliminary report. It is being sprung on us in the middle of trial. The court has ordered on this. We had a hearing on this. The court gave the defense opportunity to put us on notice of these things. We talked about these limitations. There was an agreement among the parties as to these limitations, which led to your order, Your Honor. And now the defense is going around that order. And I object to that.
Your Honor, I ask the court to think back to what's happened procedurally in this case. That FBI video didn't come around until about 2 weeks before trial. The drone video didn't come back until during trial. And most of this work has been done over the last 2 days to catch up to those exhibits. I provided this exhibit yesterday afternoon when it was first provided. The only change to it is and was a typo, which actually inures to the state's benefit by adding approximately 9 seconds.
I quibble with counsel. The FBI video was made available to counsel over 3 months ago.
That is
I don't want to, you know what, I don't want to get into it. It's been argued about before, and then we laid it aside, and at this point, I don't think I want to get into that because it isn't going to be helpful to resolution of the issues that we're after in the case. You know, I'm looking for the order. What was the date of that order?
I think it was November 2nd, Your Honor, but I'll pull it up here.
I believe that order was drafted by Mr. Binger.
It was.
And
I
I
submitted it to all parties. There was no objection to it. It was signed with no objection.
Okay.
And then the video came up after that.
Okay, I am, here it is. All right, now I say the order without objection and without really giving it a lot of scrutiny. Yet, as you know, we try a lot of cases in here, and because it came in without objection, I signed it, thinking that it covered what I had envisioned at the time of the hearing. I will tell you what I had in mind when and I haven't looked at, if there is even a transcript in existence, I don't think so. But it certainly was my impression that we were talking about video of the entire episode. And not that it certainly in my mind was not limited to the specific numbers on this observation point list that you're talking about. I'm a little bit challenged when you say, is there something that I'm saying that draws the face that you're making? Go ahead, say what you want to
I have to
say.
say, Your Honor, yesterday I was the target of your ire for disregarding your orders. Today, the defense is disregarding your order. I submitted that draft of that order to the defense. They had an opportunity to review it. They had an opportunity to object to it. We do this all the time in the court system. We submit proposed orders to the defense, to the other side, and to the court for everyone to take a look at. If anyone had a change, an objection to that, if they wanted to expand it, there was plenty of opportunity to do so. There was no response whatsoever from the defense. They never came to this court and said, the proposed order is improper, here is our version of the order. They never came to the court and said the proposed order needs to be amended in some way. They never responded at all, even though they had it, and even though they had plenty of opportunity to do so. They have every incentive to make sure that the court's order with regard to their expert witness is accurate. They have every incentive to make sure that that court order gives them the opportunity to get in all of the evidence through this expert that they feel they need to get in. Despite having that very powerful incentive, they did not object, they did not contact the court or me with any reaction to that order. You are the referee. The parties argue about things and you make a decision. We reached an agreement on this at the Daubert hearing.
I don't think on this issue.
I proposed
Not
this
this
compromise, Your Honor.
specific,
I did, because there was some
Say what
back
you
and
want.
forth about the extent of the use of force issues and all that stuff. And I said, well, what about if we just agree, Dr. Black can talk about the timing of the shots and the sense-making. And I then drafted this order. You gave the defense an opportunity to object. They didn't. You signed it. And my recollection, and again, I know you referenced the transcript, but in his preliminary report, Your Honor, all he talks about is the timing of the shots. In Event 1, the 4 shots of Rosenbaum. In Event 2, the shots against the unknown assailant, Huber. So
Yeah, you're right.
there's nothing further in his preliminary report about the extent of this entire time frame. This Exhibit 142 goes well beyond his preliminary report from July 31st. It goes well beyond what we talked about at the Daubert hearing. It goes well beyond what we agreed to that day. And it goes well beyond this court's order.
If I understand correctly what's being pursued by the state at this point, is timing sequence for the time between the friendly and the surrender to the police, which he says is a total of 400 and some, or attempted surrender to the police, which he says is a total of 4 minutes and some seconds. All of which is, every second of which I think has been analyzed here in this courtroom. That was certainly my vision at the time we discussed all this, whether it was, each part was specifically discussed in his preliminary report or not. That was my vision of what we were going to be hearing. And I guess the questions I have is, what is the prejudice to the state? Are you suggesting that what he's about to testify to, or may testify to, is going to be different with respect to the new periods of time than it is with respect to the particular periods that you identified in the order that you drafted? Or, that's number one, as to whether there's prejudice to the state. Secondly, whether you think that there is some incongruity between the periods of time that might be more fully covered by the examination of the entire time period, because those are the principal issues. We're here, you know, and you've practiced here. You were assigned here for quite a long time, some years ago, and I think that most people would say that I'm pretty open to. I want to have the whole thing presented to whomever is finding the facts, whether it's me or whether it's the jury. I want to know as much as possible rather than try to isolate particular things and say, well, that isn't. I told the story the other day about the judge from Madison who was tormented whether to grant a motion to dismiss a burglary case on failure of proof of venue, not just proof of venue, whether that municipality was in Dane County or not. And I think, really, are you really worried about this? I don't operate that way. Now, I'm not criticizing you for bringing up this issue. I think it's legitimate, but it's not something that sways my judgment in the case. And unless you can tell me that you have reason to believe that that doctor is going to testify differently about some of these other time periods within that less than 5-minute period, or that you are somehow prejudiced by the late arrival of the report, and I don't want to say late, although, okay, that's fair, then I'm going to allow the testimony to be given.
If I may respond, Your Honor.
Please.
Yesterday, as I said, I was under the court's ire.
No, I don't want to talk about.
Well,
Why don't we
I
just?
think it's a fundamental fairness issue, Your Honor.
All right, say what you want to say.
If I'm being held to obey the court's orders, I'm asking that the defense be held to that too. This is something we litigated at a Daubert hearing. We spent time on this. So.
You know, I am going to interrupt you, and then I'm going to let you talk again. But I was talking yesterday about the Constitution of the United States and how the Supreme Court has interpreted it for 50 years. That's not what we're talking about here today.
So, this is a notice issue to the state. We have not been provided proper notice of this, and clearly if the shoe were on the other foot and we tried something like this, there would be quite a kerfluffle about that. That's one point. This is, as I said earlier, it's beyond even his preliminary report. Like he's just adding new things at the last minute like this. And this is not prompted by new drone footage or anything like that. There's no mention of drone footage in this report. So to fall behind the excuse of, well, other new evidence has come forward, it doesn't change the fact that this is an expert. There are notice requirements for experts. There has been no notice of this issue. We've already litigated this, and now the defense is trying to expand it in direct violation of the court's order. One moment, Your Honor. I also wanted to point out that I think it's Exhibit 141 is a supplemental report that apparently Mr. Black prepared on October 24th, according to the date. We just got it yesterday. So again, another example of late notice here. I understand that the court wants to hear, or wants the jury to hear, the timing from the beginning of whenever we start to the end, whenever we redraw that line. I understand that. There are other ways for us to do that, of course. We can take other videos. They all have timestamps on them. This expert is not needed for that. I don't think we're going to need that time frame down to the hundredths of a second. I think even tenths of a second, even 1 second is probably close enough for the jury to understand that this is not something that took days or hours. It was a matter of minutes. So I think they can already get that point without this expert's testimony. The one specific item of prejudice that I do want to bring to the court's attention is in Exhibit 142. As I pointed out earlier, there are characterizations here.
Well, I agree with you there. Doctors, I assume he's using it for to pinpoint particular events, and I agree with you. He's not going to be permitted to do that.
so I want to be, again, I just want to make sure we're all on the same page and that I'm understanding things clearly from the court. There are, for example, observation number 7 on 142 has a characterization of Mr.
Yeah, you're right.
Rosenbaum's behavior. That will not be allowed?
He's going to have to find some way to express that, that
Not using the word
is not
plunge?
conclusory.
Change in elevation?
You know, I'm gonna try to let you do it in a prudent way, and if there's an objection, I'll deal with it.
Okay.
But yeah, I do think his objection is well stated, that there's some conclusory language in there which is to be
I can
avoided.
refer to, they're queued up. I can refer to, if he objects to that, I could just refer to it as 7.
That would seem to be unobjectionable.
I think if these are things where we're just going to show the jury that item, that moment in time, they can see it on the screen, then we don't need a witness to tell us what we're seeing. That
Well,
makes it easy.
I'm not, you know, I can't anticipate what he might ask or what your objection might be, so I'm not gonna try to.
I would also continue by objecting to observations 15,
Go slow.
15,
As, you mean to the description of the event that he gives?
yes.
Yeah, I think any of his descriptions are going to have to be non-conclusory on his part.
That's fine.
Okay, perhaps just to point to the particular moment in time and say this is at such and such an hour, I don't know.
Can I list the ones that I want to raise for, so we're...
No, because you can object when it happens, because maybe, see, if I rule on everything now, then I may be talking about things that may never become an issue, and I'd rather, the jury's in the library now, and I'd rather get them out here.
Okay. One final thing, Your Honor. If there is any data or reports that are generated by the software that Dr. Black is using when he prepares all this, I would like that. We've received a similar request from the defense this morning for Mr. Armstrong's things, so I
That's
would
fine.
like that information from the defense.
No
Is there-
problem. Do you have
Okay.
any? Does your program?
Generate them, it's gonna take a little bit of time, but they're all you can generate them all.
How much is a little bit of time?
Well, so Your Honor, the first thing I'd have to do in order to meet my understanding is I can go back in and relabel everything based on this.
You know what? I'm just trying to get the jury out here. How long are we talking about? Not why it's gonna take as long as it will. How long will it take?
To relabel everything, I'm guessing about 5 to 10 minutes.
Oh,
In
okay.
order to do the reports, Your Honor, that'll take a little bit longer.
Okay. It doesn't seem like it's gonna be a big problem. Before you're crossed, you should be able to at least get the basics, okay? Anything else?
No.
Ask the jurors to come out, please. Hey, would you
So-
put it?
I need a,
That's not going to be shown on the screen.
I need to what?
Corner to the right, and then-